Okay, ladies and gentlemen, boys and girls, we'll start our class. Okay, first of all, let me just introduce myself. Okay, my name is Dr. Chi, and okay, I'm a pupil in Tetuan Chris and Partner. So, actually, my career change is I'm not the lawyer initially. I'm a medical doctor, and then subsequently, I switched my career pathway into career legal practice. So my story is a little bit funny. I passed my LB back in 2017, and subsequently I had a lapse of almost 5 years before I set for CLP. So actually I did my CLP with a lot of helps of the individuals that I have listed down here, particularly from Mr. Patiban, Miss Lishani, Mr. Ashok Lingam, and Miss Christie, Mr. Tay, and also Mr. Gan happens to be my colleagues in the current law firm that I attach with. Okay, those are the people that had helped me to understand law better. All right. So before we delve into the class, it is worthwhile for me to, how to say, to make some disclaimers so that you understand what you are getting. It's a pro bono class, meaning that we will not charge you a single cent. And our position is very simple. Since we all agree that CLP is a tough subject, but we have no much pro bono group, that means free charity group that is in the market to help students. So our firm said, why not start from us first? Huh. So far, we have response from a few senior lawyers that will join this class. We'll see how and keep you guys updated. And okay, and because of your exam is in July, isn't it? On the first paper will be on 17th of July, so it's less than 2 months time. So it will be a little bit over ambitious should we need to cover all areas of laws, but we'll try our best. Maybe not just three of us alone. Maybe there'll be other senior lawyers seeing this moving balls, the domino effect, the snowball effect. It will get better and bigger. So hopefully this is our aim in the future. And one more thing is about the law is an evolving area. So whatever I said today, we have verified, outside had verified lah by good faith. So uh, but I could not be possibly answering all the answers in the law, that is the thing that you may want to take back from my lecture. And then since this is our first class, your feedback, constructive feedback is very much welcome. Okay. So without further ado, we'll start to look at the paper. Okay. A lot of people to ask me to send what we call my answer to them, which I did. But I think in order to develop a sense of answering the question, isn't it? You really need to know what what the LPQB want, Okay. So this is um an extracted statement from LPQB in which you must read all the new cases, and updated statutes as well as latest court case and do past year examination paper. So this is number one. Okay, you must start from now lah. Not never too late lah. Start from now. You must do so, and then candidates are required to identify the issues in the question and then discuss it supported with statute, that means law lah, as well as the decided case. You must be critical. Critical here means that say yes and at the same time say no. Why there are different positions in law? Okay, And to be very, very, very honest, you are discouraged from regurgitating statute by copying down without really putting them in association of the facts. Okay. And I think this is the last one, being the most important also. The law, you cannot miss the section. Okay. You cannot just write section 7 for dependency claim. You must write the full section. Okay. You get me? So these are the things that you need to prepare. Okay. This tort exam paper, I mean, is inside the general paper. So you have actually question 1 and question 2. Okay. As an adult student, how I did my paper, maybe my mind is not as sharp as you. So I believe very much in planning, okay? In which I will itemize, my question according to the time allocation, okay? Actually, you'll get the paper at 9, and then subsequently, you can read the paper for about 20 minutes, okay? But you are only allowed to write at 9:20 a.m. So why now you try to list your own time allocation for each question? Many people, actually GP paper, how to say, all the questions you already know in your bank. You have bank soalan, and supposedly you should be able to pass this paper. But unfortunately, due to time constraint and a little bit lack of time management, you might fail. Okay, because you fail to answer one of the question. This is fatal, and this is not very good. All right. So please do time allocation, and you must practice as such. As you can see, one question maximal time allowed is only 30 minutes maximal time. Okay, because you have 2 hours, correct? So some you might need to reduce the time to become 20 minutes. At the end, probably you get about 5 to 10 minutes time to check your answer, and as well as your roll number, your this number firasat. Okay. So okay, let's go to question A of thought. This is usually question 2A. Okay. So question 2A, you are required to identify who are the plaintiff and who are the defendants, and cause of actions involved, as well as the possible defense. All right. So be very clear. It's about cause of action, defense, plus parties. So these are the questions for question A. Okay. So the steps on how to approach this question. Okay, how do you read from the start? First, you need to identify, okay? You need to identify who to name as the parties. So whenever you have read the question, it's a long question, I believe, attached with so many medical reports, police report, etc. It's a long question, no doubt. Please identify the name of the parties and highlight with your pen and maybe a ruler and put it inside your what we call your question paper while you are reading the paper. Okay, please identify the parties first. And second thing, what you should do is see the date of the incident. Okay, see the date of the incident, as well as if there is any death had occurred on the victim, see when he died. Okay, this has very much to do with Limitation Act. As you know, for court action, we have 6 years, right? Based on Section 6 Limitation Act. But if your defendant is happen to be a governmental body, for example, public authority, and then you will have 36 months. Okay. I give you an example. Let's say, for example, now you are the plaintiff and the defendant uh, also died. The defender, the person that you sue, he also died. So how much time do you have to sue them? You have to refer to this, okay? Section 8, subsection 3, CLA, 6 months after granting of representation to the estate of the defendant. Okay, this is defendant. Be very clear in your mind first, And then if the question asks about dependency claim, so you are for the ABC, for example, the victim, the plaintiff that died in the accident. So you are claiming for dependency claim on behalf of the child, parents, or the spouse. Okay. So pursuant to this section 7, subsection 5, you have only 3 years, okay, of limitation periods after the death of your claimant, the deceased, the ABC. Okay. And then you have to read what are the likely cause of actions that arise from the facts itself. Okay. This one we'll cover shortly. And which court to bring the what we call the parties to the court. Okay. Is either session court or high court. Session court, as we all know, unlimited jurisdiction for road traffic accident. And then the cutoff point, monetary cutoff point will be less than 1 million. And high court, please identify where is the location or the residency of the defendant, okay? Because we need to sue in the court near to the defendant. This one also very important. For your next class, I think I'll elaborate further, particularly to your statement of claim here, okay? And then the types of claim arise will be your question 2B. Usually they'll ask you what types of claims or damages that you can pursue in this case. Okay, we will largely categorize them into personal injury claim, estate claim, or dependency claim. As simple as that lah. Okay. We will not cover so much on those pure economy laws, all that, because it's not inside your CLP syllabus. Okay, as well as the damages awarded by the court and the defense available. So reading the question as a whole, you must be systematic in your approach. Okay, like I have listed down. Okay. So this is LPQB punya syllabus. So they have 7 grounds of your actions. But I think to study this bulat-bulat mengikut CLP syllabus like this, I think is a little bit difficult. So what I did is I grouped them into negligence, occupier's liability, strict liability, which will cover Rylands against Fletcher, as well as vicarious liability, and nuisance. You have 2. Last one is the statutory breach of statutory duty. Okay, this one I put a question mark. I'll explain why later. Okay. From time to time, you guys, how to say, remind me, if I speak too fast, because we have 90 over slides to cover today. Okay, I hope it could be a systematic and also a rewarding session for you, so that you can know how to write based on this framework. Okay, many people still coming in. All right. Okay, so to say this is a case of negligence, you, as well as any other thought action is about ingredients. Okay, you must fulfill certain elements in order to establish a claim or negligence. Okay, these are 4 fundamental elements that you must memorize. Number 1 is duty of care. Okay, duty of care. Second, breach of the said duty of care. That means the defendant have acted or in his omission fall below the standard of care. Okay, there are various tests available. We'll discuss later. And then the causation. Causation means what? The cause and effect thing. The damage is only occur, but for the action of the defendant. Otherwise, nothing will have occurred. Okay, this is called factual causation, as well as we have legal causation, which means the damage itself is not too remote. Okay, and finally, you must look at the damage that suffered by the plaintiff. What are the damages? Is it usually because this is for tort CLP, it is not so hard. They don't ask you for difficulties to establish these 4 elements. They don't ask you pure economic injury. They don't ask you about psychiatry harm only without physical injury. They only ask you personal injury, I mean physical harm as a whole. Okay, either is personal injuries or psychiatry, recognizable psychiatry injury, consequential economic loss following by the physical harm itself. Pure economic loss, very rare, very rare. Okay, because that one you have to write an essay. Okay, and then the damages must not be too remote. So many people study negligence. They'll have a lot of confusion, particularly with number 1, duty of care issue, as well as causation issue. Okay, the thing is because duty of care issue, we have one word. The damage is reasonably foreseeable. Okay, because it's like that, Here we have reasonable foreseeability of the damage, as well as here also we put another time. It's normal, it's retrospective view by the judge. Okay, I give you one example, very simple. Ali play a flying drone. Okay, drone is in his control. Suddenly, the wind blow. Okay, then the drone fell on the head of Bala and caused injury. Okay, so the duty of care here, Ali has owed duty to Bala. Do you think? Okay, first thing the court will assess will be whether the damage itself is reasonably foreseeable. For example, the court will take in consideration whether Ali had played this sort of dangerous thing. I mean, drone is very popular and actually not so dangerous also, but it could be dangerous if something had gone wrong. Is he playing in the public whereby it's a lot of people? Okay, or he's playing in his own playground? Is the damage reasonably foreseeable by Ali, the defendant? Okay, and the damage itself is not too remote. Same thing only. As long as the damage is reasonably foreseeable by the plaintiff, then the whole cause of negligence could be established. Okay, you don't have to confuse all this. You just write like my outline. Okay, outline. So these are the approach shall be taken by the court. Now we are talking about the first element of duty of care. That means the first element of a negligence here, duty of care. All right. So first thing the court will do is not to jump to your Donahue and Stevenson and Capital Industries again, Dickman, all that. No. Okay, the court will try to find similar precedent case. Okay, for example, now the court is dealing with a road traffic accident. What he'll do is he'll find previous sort of federal court case having similar situation as such. Motor langgar kereta ataupun lorry langgar kereta, something like that. The case will be their support to draw an analogy to establish the duty of care. Okay, understand at this moment? Can understand? Hello?
Can.
Okay, cannot stop me, Okay. Okay. So second thing that you need to discuss is, okay, Donahue against Stevenson. Okay, this one you must put in two keywords: reasonable foreseeability and also proximity of the relationship. Okay, reasonably foreseeability is with regards to the damage suffered by the plaintiff, and the said proximity is the nexus of plaintiff as well as the defendant. Are they closely and directly affected by the act or omission done by the plaintiff? Okay, as simple as that. Huh? Okay, you put Donahue and Stevenson and put this reasonable foreseeability plus proximity, whereby corporal industries again, Dickman, you have to fulfill three elements. Okay, the only element that is distinguished from Donahue and Stevenson here would be last one: fair, just, and reasonable. Okay, that means the court decide whether the situation given now can fit in to say that plaintiff actually owe a duty of care towards the defendant, owe the duty of care against the plaintiff. Okay, usually Caporal and Dickman, it applies to new condition. I mean, never have any case in Malaysia. For example, I give you one simple thing lah. Now we have those AI punya, no, you don't have to drive car, isn't it? Those electrical car. Okay, you being the main passenger, but you don't put your hands over the steering. But suddenly, this electrical vehicle crashed into a motorcycle. So how to say you have reasonably foresee this could happen? So what is the relationship of your party? It was in fact actually you rely on the electrical car, and then you were sleeping during driving. Okay, so how was it? So this is the time whereby because the negligence itself is evolving, is changing and adapting itself to the new environment. So this one, Caparo against Dickman, is applicable to novel situation because the FJR thing, in which it had given the court to at its discretion to determine whether there is a duty of care. And this is apparently affirmed in our case of TMB against Batu Kemas. So I hope you are clear. Okay. So from the facts that I've said to you, the court will draw analogy. So it's very important for you just to memorize a few cases that probably will come up and fit into your case, your problem case when your situation. For example, road traffic accidents, you just remember Lim Kabi and also KR taxi against Zahara will be a good case. It will be repeating all over again in your B of your exam. And industry accidents, you can remember two: Chang Yi-chong against Liu Tai and DBKL against Ong Kok Peng. Whereby medical negligence, I think you can remember one, that is Fufiona case. This one is a must, this one. Very famous landmark case. As well as legal profession negligence, you can remember Yong and Ko against Wee Hood Tech, or this Tetuan Arif and Ko case. You can also borrow some of your PP when your knowledge into this. But I don't think legal professional negligence could occur because that one will be fall under another category of discussion already. Negligent misstatement. So I really don't think. Okay. So outline of this negligence. Okay, how do you write? DOC. Okay, this is the outline. Whenever I put a star, you go back and revise one more time. Okay, ABC, plaintiff bears the legal burden of proof on balance of probability to establish the claim of negligence on defendant, DF. Okay, the real name, inside your question, you must put, this is just a framework to guide you on how to write. Okay, he needs to satisfy the following elements: duty of care. Okay, this one analogy, all that you don't use. Okay, I will put my first sentence to determine whether is there any established precedent or not. I will say both the ABC and the EF are root users or employer-employee relationship, doctor-patient relationship, etc., who involve in accident. Okay, full stop. The court is likely to draw an analogy from the precedent case law. That you put in the case accordingly. This case here must tally to your analogy. That means to say, road traffic accident, you don't go and put Fufiona lah. Okay, you must put Limkabi or the one that I said KR taxi against Sahara. So the court know, it is a form of established duty of care. So no need to think much, Okay, to gain further marks, you go second paragraph. Referring to neighborhood principle established in Donahue against Stevenson, ABC has suffered from personal injuries as damage that the defendant, DEF, could reasonably foresee. So I already tell them foreseeability. One more sentence here. ABC appeared to be the person that was closely and directly affected. You can say by the act of DEF also can. So I want to tell them, I want to establish this neighbor principle already. Okay, and then I conclude. The situation given in the question per se is not a novel case based on your personal understanding lah. So I use the British case of Robinson, okay, to suggest that the 3 stages test in Kaparo and Dickman, as affirmed in federal court decision of Batu Kemas against the MB, then because I cannot just write like that, I have to say a very simple form. Foreseeability, proximity, and FJR shall not be applied here. And then lastly, you submit whether this element of negligence been established. I will say, having discussed so, very simple language, having discussed so, it is submit that the defendant owe a duty of care to ABC. Okay, finish at this point. Okay, can you understand? So we go to second element. Remember, we have 4 elements. Each element must be discussed, but in brief, otherwise no time at all. Okay. So second element will be breach of duty of care. Okay. First thing, you must identify which category of the defendant fall into. Okay. If it is a non-professional category, then you can write like this. DEF, this is the name, given in the problem scenario. It could be man, it could be obvious, depends. Okay, you change accordingly. Okay, this is just to provide you with a script so that you are not so blank during your examination. Okay, DEF had breached the duty by acting below the standard of care that he ought to exercise as driver lah, factory owner or organizer of the event, etc. Okay, the appropriate test for standard of care applied in given scenario is reasonable man test. Okay, KR taxi against Sahara. Okay, this one very important. As defendant must exercise care as a reasonably competent driver. However, this is where you put the faults. Why he fell short of the standard of care. Then you copy from the fact. All right. For example, you have failed to keep proper outlook, failed to break, failed to give sufficient warning, etc. And then again, you conclude, having discussed so, it is submitted that DEF had reached the duty of care. Okay. Okay. So second one, if it is professional category, okay, except medical, okay, then you reiterate whatever your statement, okay, and then you change the test of standard of care here to be BOLAM. Okay, BOLAM, you must set this sentence in accordance with a practice acceptable as proper by a responsible body of professionals. This is BOLAM. That means we compare the professional defendant with another similar expert in his field. Okay, very simple. So this one very important. BOLAM. Okay, so you can extract from the facts and put the faults on the defendant. For example, fail to assess stability of the building structure, fail to prevent. So quick question, I get similar with case name. Can we use capital site tenaga despite it's not? Actually you can, but the proper one is again analogy, Donahue and Caparo. Usually Caparo is not the main thing to establish duty of care. You get me? So okay, never mind, we continue. Okay. So the fourth thing you have to look. Okay. Having discussed so, it is submitted that the defendant had reached the duty of care. Okay. If it is a medical one, on top of BOLAM, you have to add in FUFIONA. Okay, because medical treatment is not as simple as other professionals. We'll have first the consultation thing. Consultation, that means you come to the clinic or you come to the hospital, the doctor will consult you first. What's your problem? Do you have headache? Do you have flu, fever, etc.? Okay. During the consultation, by right, if you want to proceed to diagnosis and treatment investigation, all that parts, you will have to get informed consent from your patient. Okay, so and so, I need to perform COVID test on you. Okay, may I use this whatever the stick to go into your nostril and then take out some secretion? Is it okay for you to allow me to do this? You'll feel a little bit irritation, something like that. So this is informed consent, you know. So nowadays, the federal court had held that in order to fall short of standard of care, two tests here. FUFIONA will be the one that concerned to informed consent. That means all material risks that had attached significance to the plaintiff must be revealed to plaintiff, and the plaintiff must have consented to do it. And then BOLAM is again whether we follow the standard operating procedure adopted by professional body of our group's members, like medical board or whatever. Okay, and then you can writing this, and then you can write this DF had whatever faults you can derive from the question you put inside. Fail to take any reasonable steps to complete the surgery, for example. Fail to follow proper procedures, etc. And then you submit one more time. Okay, so three different categories. Please remember. So negligence, the third part would be causation. Causation can come in factual causation and legal causation. Factual causation means the accident itself did not have a break of its change. That means to say the whole loop itself, the whole loop, the whole loop, the whole loop, something like that, is complete. There's no, okay, for example, you hit the patient suffer from injury, and then subsequently the injury got worsened, and then patient die like this. So the causation chain itself is not broken, not like this. You hit the patient, and then subsequently, the patient was lying in the road like this, okay? And then one lorry come pula, hit him, and then he died. Not finished yet. Another car lose control. So the agent, I mean the top officer, there will be a lot, So usually the exam will not give you such a complicated scenario. Usually they'll give you one guy solely responsible for the whole damages of the plaintiff. Okay, as simple as that. So you will have only need to use but for test. Do not attempt to argue those material contribution, the McGee principle, Fairchild principle. No, okay, you must use only but for. Okay, but for test, this is the way that you should write, and then you must emphasize there's no break in the chain of causation, solely responsible, and then absence of novus actus interveniens. That means intervening events that might break the chain of causation, or any contributory party to the damage. That means there's no independent or joint fissure here. Okay, can get me? This one so complete, but for. But for. And then legal causation is highly related damage part, in which, okay, the damage that suffer by plaintiff is the type that would be reasonably foreseeable by defendant. So I told you just now it's a retrospective looking. So duty of care, you see this word. Down here also you see this word. Causation part also you see this word. And again, later damage, you will see this word also. Okay, the Weger-Moe test. Okay, it's very important. Weger-Moe. Okay. Okay, so damages. Damage, sorry, not damages, different. Damage means whatever harm that suffered from by the plaintiff, and damages is the money that claimed by the plaintiff. So different terminology altogether. So you must remember. So I will give you an outline how to write damage. ABC had suffered from damage as a result of breach of duty on part of DEF. The damage that DEF had suffered, for example, this one, please refer back to your scenario. Do not copy bulat-bulat, but this is about to be there lah. I mean, I prepared these templates for a reason. You just have to change the fracture to laceration, no, not laceration, to brain injury probably, okay, to abdominal injury, okay, etc. And psychiatry harm, usually they'll give PTSD or depression lah, because everybody will have aware of this is psychiatry disease that is recognizable, okay? Very simple, you just write, and according to this style also can. And the particulars of the damage will be elaborated further in answer 2B. Okay, this is good. And the answer first mentioned is not too remote. Again, you use the Weger-Moe test. Okay. I think I answer your question later in a group because we still have a lot, Otherwise, 3 hours also cannot finish. And right. As a conclusion, all 4 elements of negligence are satisfied. Then you have to submit one more time. ABC would likely to have a negligence claim on EF. Okay, so this is how you should write. Okay. All right, good. So do what you love what you do, please. And then we'll go to second course of action. Lately, I found out that LPQB had switched their favorites course of action from negligence. Last time, easy only, it's not easy. It's very obvious that tort is equalized to negligence. But nowadays, you are required to know occupier's liability as well as some other cause of actions that I'm about to tell you. Okay, so like negligence, it is a tort action. So like any other tort action, you must fulfill the ingredients of that tort. Okay, so there are 5 elements of the tort. Okay, as you can see, number 1 would be occupiers of the premise, in which you need to define what is premise and what is occupiers. And then subsequently, once you have established that the occupiers, I mean the defendant normally lah, had control over that premise, then there is an assumption of responsibility. That means there is automatic imposed duty of care towards whoever that enter into the premise. Okay, now you can see 2, 3, 4, 5 are all overlaps with negligence. Some judges, but not all, some they have their different thinking. Some judges agreed that the fact occupier's liability is a subspecies of negligence, which I also sort of agree, because they are very close to each other, Okay, so duty of care, breach of duty of care. Breach of duty of care will, the standard exercise will need to depends on 4 parts of the entrance, namely the contractual entrance, invitees, licensee, or trespasser. Each level standard of care would be different. Highest rank will be the contractual entrance. We'll discuss later. The causation is again but for. That means if it is not for your act, then damages will not happen on the plaintiff. Okay, but for, and damage must be reasonably foreseeable. So, okay, since this is a disputable area, whether this is part of the negligence or not, so usually to play safe lah, I will not put any test, okay, from the negligence. I will not import any case law from negligence cases into here. Okay, I'm playing safe. I tell you, I'm playing safe. So even though causation here we have a Bernard, but for case, but I cannot put that case because later on I confuse the examiner. Susah. Okay. So we have overlapping element. Clearly, this is so. Okay, so first thing to do, okay, how to write. So you write in such a way that this is the star. I put for you already, you just, after this lecture, the slides will be distributed all over. You have a look with particular attention on this one with the star. Because I realize most of the students, they know the law, but they cannot write. They cannot write in time. If giving them maybe half a day, yes, the answer sheet will look perfect. But in the pressure of time during examination, I think this is very difficult to do. And it will be best for you just to have a template and then you just fill in the blank lah. Okay, play safe and pass the exam, finish it lah. Okay, so according to Lautin C, premise means any fixed or movable structures. So remember this. Gaia complex, shopping complex is your last year question, my paper lah. It's a building falling within the ambit of the definition of the premise. So DEF is the occupiers of Gaia shopping complex, although he's not an owner. Ownership possession is not very important to define occupiers, but the keyword here is control, whether he had immediate supervision and control of that premise. Okay, control means whether he can have that sort of power to permit or restrict the entry of that your plaintiff the ABC from entering into the premise itself. Okay, this is well established in case of Witt against Lecon. Okay, so as the occupier of the premise, there is a assumption of responsibility for defendant. to owe a duty of care towards ABC. And the standard of care needs to be exercised by defendant is largely depending on the class entrants, namely contractual entrant, invitees, licensees, or trespasser. So after you write all this, the DF here, please change to the name of your defendant, the real name of your defendant. For example, the Gaia Shopping Corporation, if I'm not mistaken. Okay, please. And then straight away, you have to identify which class the plaintiff is in. Okay, we have 4 classes, correct? First is the contractual entrance. Okay. Oh, so Sir Patiban is here. Hello, sir. Welcome to my class, pula. Right. So, okay. The first one, contractual entrance, by the meaning of the word itself, that means there's a contractual relationship between the occupier plus the plaintiff that you are representing. Okay, they are contracting for each other. A good example would be hotel guests, the movie ticket purchaser, or tenant-landlord relationship. Okay, there's an agreement, okay, or they are paying for the service rendered to them. Okay, so this is contractual entrance. Okay, the case referred is this Sri Inai against Yong Yit Sui. Okay, this is a disastrous fire involving an international school back in Penang. Okay, in McLennan against Sega, it is established that the defendant would owe the highest duty of care to ABC as contractual entrant. Okay, so you further elaborate, so the danger that available or exists in that building must not be, need not, that means even it is hidden or even it is unusual, the occupier could be held liable. That means to say, suddenly you went into the movie theater and the ceiling collapsed. Surely you will say this is an unusual thing, isn't it? But as long as you belong to this contractual entrant category, you pay for the ticket, okay? You will be deemed with the highest standard of care should be exercised on part of defendant, okay? And then subsequently, you must elaborate, just like negligence, you must copy and paste from the facts how defendant had failed to provide the said standard of care. Other notice, for example, no sufficient regular checkup towards the electricity system or the lift, whatever. You put in your own way. Okay, this is just a template for your reference. All right. And then second, we have invitees. Invitees are someone that come, okay, not under contractual duty, but they are either allowed by law. For example, the one that read your meters, home meters, the electricity meter, okay, water meter, all that, or regular shopper. The regular shopper may not buy anything from you yet, they just window shopping. They just enter your shop, to see only before they buy. However, they will be deemed to have some economic interest in between the party. That's why when you see this sort of occupiers liability, the class of the entrance, you must identify, is there any interest behind that? Paying or can generate profits for both. Okay, something like that. Okay, so as I was said, and this good case law, Kong Dabari against government of Sarawak, this one, an explosion happens in public bank of Sarawak. Explosion. The customer went there to withdraw money and got injured badly. So they are deemed to be invitees, invitees. Okay. So what are the standards that we ought to impose on part of defendant in related to the groups of invitees? Okay. Unusual danger must not be there. Okay. And occupiers knowledge will be taken into consideration. That means occupiers know something is wrong but fail to repair. Suddenly the thing drop, habis. Okay. And plaintiff knowledge also equally will be taken into consideration. If plaintiff went to a movie theater, but instead sitting, he knew that the chair itself is a bit shaky, but he still sit on it, and then the chair fell. He got injured, cracked his neck. He should have been partially at fault. Sometimes this could void the responsibility of the defendant also. So these are the factors. And then again, you have to copy and paste from the fact. Occupier's liability, the key words here is usually this one: failure to take precautions. Sorry, not this one. Failure to put sufficient warning or notice towards the said danger. This is standard across all four types of entrance. Okay. And then third will be licensee. Licensee is the person that enters the premise free of charge. Okay. The plaintiff or the licensee themselves did not bring any interest, economical interest, to the defendant at all. Okay. There are three categories here. Okay. Entrant as of right, usually those public place like toilet in the highway R&R. Okay. Public swimming pool, library, for example. You don't have to pay, then you just go there. Okay. But something bad happened. Okay. Social visitor, as this is self-explanatory. That means your guest your guest, you invited the guest into your house, so he enter under licensee. Okay. Or the last group is how to say, the last group is implied entrant. That means to say, for example, you have a huge garden, but this is not gate and guarded, nothing. And then there are a lot of flowers that could attract the attention of any bypassers. This doctrine of allurement or attraction would apply, because it is you that put the flowers to attract bypassers. Bypassers surely like me, curious type. They'll see, wow, very beautiful flowers. Suddenly I went inside. Okay, there's a concealed trap. There's a trap for mouse, and then it caught my fingers. My toes. Okay, habis, man. If you set up those kind of trap which is concealed, and the occupiers had knowledge pertaining to the danger. Okay, for example, you dig a hole before I could reach these flowers. You want to prevent people from stealing. You dig a hole, and then I fell into that hole before I could see the flower. You're still liable. Okay, so these are the standard of care for licensee. Okay, like I said, you have to hammer the defendant why he had failed to provide or why he fell short of the standard of care by exerting the facts from the question. Just put whatever facts, don't think too much, just copy and cut the exact sentence from the your question. Okay. And the last category would be trespasser. Trespasser is the one that without any express or implied permission, he entered the premise of the occupiers. Okay, so the occupiers also have totally no knowledge about the existence of this trespasser. Okay, so what you should write is you must establish the connection first. ABC is entering ABC, this DEF, DEF, sorry for the mistake, I'll correct it later, without any permission. So when he lost his way, DEF was not at material time aware of his entrance to the premise. Therefore, he is a trespasser. Be clear. Just be clear with the class of the entrance first. And then the court will take into consideration a few factors to determine standard of care imposed on part of defendant. Usually in this sort of case, lowest standard of care needed. Usually it is based on that sort of a humanitarian principle. You understand? You should not let, there's a possibility that, okay, you leave your bungalow empty. There will be thief, right? Okay, based on our security scenario, okay, there will be thief. So what you do is, the walkway or the stairs is a bit collapsing already. It couldn't even hold one man's weight. You leave it there. Purposely, that means to say, when thief goes up, then the whole stairs can collapse. Can if you have done so, probably you'll be even liable to the trespasser. Okay, the good case here is Lembaga Electric Negara against Ramakrishnan. So this case involved a few kids. They go and those electrical big station. They want to find bird, the nest, the nest of the birds to play lah. But then they got electrocuted. So because they are children, sometimes children, for invitees and this trespass group, if you have encountered any children, the court usually will have a soft spot against the children, because the children cannot act like a reasonable adult. They cannot think much, they just want to play. So you might be held liable for occupier's liability if the so-called victim is children type lah. Children saya paling takut lah. Better don't come out lah. Okay. And to continue, and you must finish up the other elements, which is causation, but don't put any case in regards to negligence, and also the damages is reasonably foreseeable. Okay. So in submission, ABC is likely to establish the claim on occupier's liability on defendant based on the above arguments. So this is the way that you should have done. All right. Any question, please put in the group. I try to finish up by 10 because we still have the 1 hour to go, So many this okay. Okay, right. Ryland and Fletcher's, this is also part of your syllabus. Hopefully it doesn't come out, because Ryland and Fletcher's, another thing, it is also very closely connected to private nuisance. So sometimes these two you can plead together, So the first element we'll look at is, you place something on the land that belongs to you, that something was likely to cause mischief. The mischief here is some sort of gangguan. That means to say some disturbance to others. It's not dangerous. The word dangerous was never used, but somehow or rather, in Ryland's against Fletcher case, the case only involved reservoir water. Okay, so this thing even water, so much so natural thing to be, you put a water tank, all that is nothing abnormal. But if it's escape and it could cause this word mischief, then the court will take into account. Okay. Second thing is non-natural use of land. Use the correct word here. Is non-natural. Natural means that means a little bit abnormal, not in the usual ordinary use of land. Okay, and the thing must escape. Escape means from one tenement to another. That means from the defendant's land to the plaintiff's land. and then there must be special damages as a result of this. Okay. So, okay, this is the diagrams to explain Rylance and Fletcher case. So Rylance apparently had store a reservoir of water on his part of the land, However, this one day the what we call the weather is not so good. Subsequently, there's a loose landslide, and then the water went down here and then caused damages to Fletcher's mines and shaft. So this is the whole the cautious action, the elements is based on this diagram, Okay. So as far as we have recall, mischief, non-natural use, escape, and then damages. So can recall, okay. So in Malaysia position, Ryland and Fletcher's are often pleaded together with private nuisance. In the case like fire, okay, petrol, water also can, and this combustible cut vegetation, noxious fumes, and also loose earth. Okay, so these are the things that you must think, okay, must think in order to establish your R&F course of action. 4. So what I'll write is, the defendant had stored noxious fumes, which is a tangible item that is likely to cause, like I say, mischief is the word, it's not dangerous. I have reference from Janet and also Bullen and Lick. It all said the words mischief here to ABC, who is the plaintiff here, on his land. As generally understood, noxious fume would cause serious harm to the claimant who might accidentally breathe in the film. This one I based on the case of Datuk Harnam Singh against Rena Ling Sendirian Berhad. Okay. This one also quite popular case there. You can read. Okay. So again, non-natural means a question of facts here. I will place my argument like this. BF has artificially introduced on the land potentially dangerous substance and suggested that the user will not be non-natural if it is an ordinary use. Okay, this one also I have far bulat from Bulan and Lick lah. Because this sort of how to say, this sort of thought, every wording matters, every wording matters. And then subsequently, you must explain what does it mean by escape. The said mischief thing had escaped from defendant's land to ABC's adjacent land. So usually this is the case here, lah. Okay. And lastly, there must be proof of damage. Okay, as a consequence, ABC suffered from damage. For example, personal injuries, property damage, etc. So this case, I think a little bit difficult for you to memorize. I think you just memorize Ryland and Fletcher, Hanam Singh, enough good. I don't think you are so unlucky good to get this course of action in your exam. Lama. Then you probably need to plead itu nuisance pula. Wow, that one is even harder, man. Okay, next, we'll move to vicarious liability. Okay, vicarious liability, you have to establish 3 elements. Whenever I say the elements, you must put down in your answer. So I hope this is understood, at least by now. All elements you must memorize, okay? So vicarious liability is actually what happened. Okay, the employee, I'm the boss, I have one employee. Okay, my employee had committed negligence. Okay, but my employee seems not so well to do. Okay, I'm the boss and I'm listed company, for example. So it would be better off to pursue the so-called vicarious liability. It will be better to sue me as the employee represent me, something like that. Okay, so the 3 elements you must establish. So you are suing the boss, here. Okay. Number one, it would be employer and employee relationship. You must establish this. Number two, the employee must have committed the tort during the course of employment, not at his holiday, he went somewhere else after office hour, nothing to do with the work. He go and he drinks some alcohol and then knock somebody, and then everything will be blamed on you. It's not like that. So second thing is during the course of employment. And lastly, the employee must be held liable for negligence. Okay. So what I'll write is something like this. There are several tests to establish the first element, employer and employee relationship, in which control test, organization test, multifactorial test, and also last one is the non-delegable duty. Okay, so usually, they won't ask so difficult. They'll ask the control, the first one being the very direct one. So you have to establish. Okay, so I will plead in a way that the co-defendant, PQR Sendirian Berhad, which is the boss lah, and the first defendant, DEF, appear to be in employer and employee relationship with the control test, in which the fact given reveal that DEF was working under the employment agreement, control and instruction, and getting remuneration or wages by PQR Sendirian Berhad. So this is your submission. Okay, so a few things to ponder would be Grab driver, Food Panda, because I think they might fall under the category of those independent contractor. Okay, independent contractor. But I don't think you are so lucky to get this. Okay, control test. Please remember the control test. Okay. The second element would be cost of employment. So cost of employment also very important. The employee must be working or through and fro from his working place. That's it. According to this case, Sing Kong Logistics against Plus the highway. Okay. So I will plead as such. When the accident happened, DF was at material time working for co-defendant PQR Sendirian Berhad. DF was driving the lorry to deliver goods as instructed by co-defendant in the course of employment. So you do not need to regurgitate the law, So what I'm trying to say here, when you try to write this sort of outline of answer, you incorporate whatever facts inside in application of your law, okay, and also principles. Okay, the last element of vicarious liability is the court must have found defendant as the employee to be held for negligence. As simple as that. This one, no dispute. Okay. And then we have to move to what we call statutory nuisance. Okay. Nuisance, we have a few. Statutory nuisance, public nuisance, as well as private nuisance. In my personal opinion here, this statutory nuisance, I don't think they will come out because it is usually conferred by specific section in the law. So skip it lah. And public nuisance, this one also, I think it will be worthwhile for you just to skip it. You focus on the previous chapters of the course of action better, especially negligence and occupiers liability and vicarious liability. That one don't miss. Okay, so this one, public nuisance, you must fulfill 3 elements. Okay, number 1 is the act materially affects the reasonable comfort and convenience of the life of part of the society. So that means the thing affects the public as a whole. And then the plaintiff must have suffered damage. And third element is the defendant have known or presumed to have known this sort of nuisance, but fail to take any action to prevent it from keep on happening. Okay? The huge problem for you to take public nuisance would be, because usually public nuisance, your litigant, I mean the defendant, would be public authority, like your Majlis Perbandaran, like those plus the pelabuhan, project Lebuh Raya Utara Selatan, all these uh, uh, governmental body, big organization, that's why they cause inconvenience to the society. So usually public nuisance is actionable in tort as well as in crime. So there's a doctrine that since this is a public wrong, it should be corrected by our AG, our Attorney General. So you as a private person, as a private individual to initiate public nuisance, you must get AG or state AG's consent. This is, if I'm not mistaken, is under Section 8 of your Government Proceeding Act. This one later I add in, okay, for you guys. So not easy to have your case to be success. And personally, I don't think this sort of question is that popular in the exam. Okay, private nuisance, yes, sometimes yes. Okay, so private nuisance involve two elements. Okay, first element would be unlawful interference. So you must remember, each word in the thought is very, very crucial. What does it mean by unlawful? That means the private party here, I mean the private defendant here, must have done something that is illegal, too noisy, disrupting the peace, for example, and then causing special damages, special damage to the plaintiff in regards to his personal use, comfort, enjoy, and any interest that the person may have over his land. So the case law here that you can use is O Kian Hu against Persatuan Penduduk di Wilayah Equestrian. This one is one case here. Like, okay, just imagine, okay, our plaintiff here lives in a gate and guarded property, a residency area. There is some sort of Persatuan Penduduk, isn't it? Like community punya committee lah. Okay, they set up the boom gate, you only have card P, then the boom gate will open. Okay, then your car can pass. This is the action whereby Mr. O here refused to comply with our Persatuan Penduduk. He refused to pay the monthly management fee, and then he sued for private nuisance because the establishment of this boom gate had caused interference of his personal use of the land that owned by him. Okay, so why is it unlawful? It's because the penduduk, the Persatuan Penduduk never applied for a license okay, to set up this boom. So this is the so-called the elements of thought that you must bear in mind. Okay, so another case would be Wisma Puncak Emas against Dr. Donald as well. You can write. Okay, so these are the examples of private nuisance that you can rely on. So again, Dr. Harnam Singh against Renal Link. So this, like I said, sometimes it is closely related to Ryland and Fletcher. Sometimes negligence also can. So whenever you plead for CLP purpose, don't go haywire. Just choose the one that really suitable and you are really confident in. Don't go and plead and it turns out otherwise. Okay, choose the one, I mean the course of action that you really, really well versed with. Then you plead. Okay, so recently my master firm has one interesting case. We are for the plaintiff, and there are trees. There are the plaintiff as well as the defendant are staying next to each other. It's a terrace house. So for the purpose of feng shui, okay, this neighbor here grows trees, on the land beside the wall of my plaintiff lah. And then subsequently the root went encroaching, and then the trees also, the branches of the trees went encroaching. The buah-buahan, the fruits drop, the leaves also drop inside the plaintiff's house. Okay, so they bring an action for nuisance, for private nuisance. Okay. So again, I could not repeat myself. If you just judge on the situation, sometimes it could overlap with negligence and Ryland and Fletcher, which is very, very common. All right. So last, we go to the cause of action of breach of statutory duty. This one even harder, and I think it comes out last year. Frankly speaking, I dare not plead this during my examination. I want to play safe. Okay, 4 elements of statutory duty breach can occur. Okay, this breach, the statute itself usually is granted by our state, correct? So usually any offense against the statute will be a criminal case. But somehow or rather, some statute, especially Road Traffic Act, the what we call the Factory Machineries Act, last year case was about the Occupational Safety and Health Act. They will have a specific provision, inside the whole statute. But then the specific one, I doubt you read lah. You cannot read. Now you also don't have time to read your criminal rules of court already, where you have time to read all this. You see the statute here. So it's a little bit out lah. I think to plead this is a bit out, but you roughly understand how it works. Okay, that means to say, first element, the so-called the damage is within the ambit of the statute. You cannot simply pick one statute and say that this is Government Proceeding Act 1956 or Police Act 1969, 67. Cannot. You have to pick specific section. Okay, and then some more. Second element, the statutory duty must have enabled you to have taken this private action. Okay, very difficult, specific, everything is specific, cannot be general. And the statutory duty was not fulfilled by the authority, usually authority. And breach of duty had caused plaintiff's injury. Okay, so you pray hard this doesn't come out this year. Okay, otherwise a little bit difficult lah. But it is in your syllabus, Okay. So now we go to general defenses. Okay, general defenses. Okay, for torts action, you will have a lot of defenses. Okay, for example, you can plead limitation period, like I told you, based on the date of the accident itself or the time of death of the disease. Okay, you can plead limitation as your absolute defense, okay, to void you from this liability. Okay, so you are actually now talk about general defense. You are acting for the defendant already. Okay, you must think in the shoes as a defendant. So actually what you do is you cast doubt on the elements. You see, just now when we learn negligence, the elements will be duty of care, the breach of duty of care by falling short within the standard of care, and then causation and damage. So you're cast doubt on 4. You'll say there's no duty of care. Oh, I don't even know this guy. Okay. You will say I exercise according to the SOP inside my factory. Nothing wrong. Okay. And then you will say the causation is not from me. It's multifactorial. There are multiple fees coming, okay? Not just contribute by me. Yes, I release the gas, for example. Okay, later on, you can absolutely have the slide, because anyhow, the principle of pro bono means everything free, okay? And then the damages, the damage is not too remote. Please correct yourself, damage and damages different. Damages money. Damage means the harm involved. Okay, damage is not too remote. You cast doubt on the four elements. Wherever you have a cause of action of tort, these elements itself will be your separate defense. Okay, can understand? And then you can plead beyond the control of God. Beyond the control of the defendant, which means there's an act of God, thunderstorm coming, hurricane, the wind blow, the whole building collapse, all that lah. Okay, latent defect of the product itself and agony of moment means suddenly, okay, you are driving a car, suddenly in front, the lorry, the land, and then you feel so much so danger to yourself, certainly you have to make a avoidance, isn't it? But that avoidance was later on proved to be a mistake. You hit somebody, so you can plead. But you cannot list out all the defenses as I have written for you here. You have to base on the factual scenario given in the question. Otherwise, you'll be how to say, you just copy and cut lah. Then you're not good. I mean, you'll not get the good marks. This is CLP, professional examination. Okay, so mechanical defect, exclusion clause, warning, all that. This one I told you before is a good defense for occupier's liability. But in order for you to establish exclusion clause, you must further learn about the doctrine of incorporation and also contra preferendum rules. Okay, this one is similar to your contract lah. That means the clause itself is very clear cut, not ambiguous, and then it was given before the victim enter into the premise, something like that lah. So usually you see shopping floor, this sort of slippery floor with the symbol that you fell down. This is very clear. You will fall because of slippery floor, and then this will be a sufficient notice for voiding of liability. Okay, other than that, it's just joint officers, two or more players, like I've said to you. Statutory breach, when the police bombard, they all carry out their duties, so this be pleaded. And liability to gratuitous services, this one you can plead to reduce the apportionment of liability, because you are doing it free, suddenly something went wrong. So good faith sometimes will gain some sympathy in the court. So again, I could not actually help myself not to repeat this sentence. Please do not regurgitate every defense. Please write according to the fact and not assumption. Okay, so important defenses would be voluntary non-fit injuria, that means consent. So there are three criteria to be fulfilled, in which the plaintiff must have full knowledge of the nature and extent of the risk, and then the plaintiff must have consent or assume the risk to be there. Okay, and the consent or assumption of the risk must be voluntary. So you have three keywords here lah: full knowledge with regards of the risk, and consent to the said risk, and voluntary submission on the part of your client. I mean the plaintiff. Okay, so contributory negligence. This is must memorize. Every cases, every question 10 years ago, since 10 years ago, has got this element, contributory negligence. So you must argue in such a way. It is a partial defense, which reduce the amount of damage pursuant to Section 12, subsection 1, Civil Law Act. And you must switch the position. You must say this word: the defendant must prove on balance of probability that the plaintiff had failed to take reasonable care of himself and contributed to his own injury. Okay, so you must learn how to write like this. So further on, you can add some words as extracted from the problem scenario given. For example, he was not wearing his helmet while driving. Okay, he was equally speeding, or there's some alcohol intoxication, okay, found in his part. So these are all categorized under contributory negligence. Okay, and I hope you are following me so far, because this is quite a bulky one. I just try to make it sweet and short. Okay, so next we go to damages. The damage, sorry, why I keep on saying damages? Damage. Okay, so this will be your question B. Okay, so types of damage, it will be largely depends on the defendant's status and what question they ask. Sometimes they ask you just list down personal injuries only. Wow, then you clap your hands. But if you have complicated case whereby you have some plaintiff that are alive, and at the same time you have plaintiffs that are dead, oh, then you have to argue a lot. You have to argue on, if let's say the plaintiff is alive, then you have to go for personal injuries claim plus minus property claim, and then that punya plaintiff, then you have to go for dependency claim, estate claim, or even both plus minus property claim. But the one that confirm will come out is this personal injuries will surely happen in your question 2, okay, punya scenario. Okay, so personal injuries, okay, to make your life easier, you have to make several headings, before you go to exam hall. You must make some short notes about how to write personal injuries claim. So largely, the damages here will be divided into special damage and also general damage. Special damage refer to any damage that occur before the trial. That means with the proof of receipt, any pecuniary loss that suffered by the victim side before the trial. Okay, this one is quantifiable. That means we have receipt, we have clear amount of money. Usually medical fees, medical is the apparatus fee, the traditional medicine, the logistic fee, how much, the pre-trial loss of earnings, working for 6 months, for example. These are the example that you should put under special damage. The general damage is the one that is difficult. Later we discuss. This one is to be assessed by the court. Okay, it could cover post-trial monetary loss or non-monetary loss to be assessed by the court. Because sometimes patients suffer from those pain and suffering, depression, all that cannot be quantified. So the court need to evaluate the situation well. Okay, so these are the heading. Okay, remember I said this personal injuries has 2 heading: special damage and general damage. So under special damage, you must don't forget about the case law first. Just remember the framework. Oh, special damage, I must list down medical expenses, equipment, transportation, cost of care during hospitalization, pre-trial loss of earning, cost of other expenses, for example, medical reports, police report, the sketch plan, all that are claimable, inclusive of legal fee. Because usually the question will say the plaintiff or their family consulted you. So this one you can include. Okay, remember the heading first. Then only you go to remember those case law. Okay, don't confuse yourself. This topic is a bit messy. I think I don't like this part, actually. I myself had a hard time to digest until I developed this formula. So due to the restraint of time, you cannot be possibly vomiting out all you know. So you must tailor with your question asked. That means to say, if there is a government hospital, you just put Chai Yi Chong. Government hospital fees according to Chai Yi Chong is claimable. No need put overseas treatment, and then subsequently, if government to private, is there any contingency deduction, etc. You make your sentence look haywire. Subsequently, you waste a lot of time and energy to elaborate on unnecessary facts, okay, based on your own assumption. So this is not good. If there is a wheelchair, crutches, or he needs some oxygen mask, for example, you can put the case of Trimalai, okay, as well as the transportation fee, all based on your question scenario. Okay, the general damage is the one that quite difficult for personal injuries because it has got 11. This is based on my personal point of view. Some will say not so much, but I have referred to some books. It memang ada 11 headings. So you better list down those and argue accordingly. Okay, pain and suffering. Pain and suffering refer to, I will put it this way lah, pain and suffering, and then I'll underline, and then I'll put, okay, ABC suffered physical or emotional distress as a result of the said tortious act. For instance, ABC had been hospitalized, suffer from, you copy and cut from your medical report. Inside, the injuries are so lengthy. Wow, this fracture, rib 4 to 6 rib, left side fracture, subsequently lung contusion, abrasion of right upper limbs, etc., etc. So you just copy, okay? So, and then you can comment if there is any loss of amenities. That means ABC, after the accident, could not enjoy his hobbies. For example, hiking the mountain, cycling, okay, playing badminton, because his leg, after the fracture, he was becoming a cripple, okay, cannot walk stably. So that means there is element of loss of amenities here. So you just copy and paste from the scenario given. The case that you should memorize would be Yang Sabia and Limpochu. Okay, stop at that lah. Don't go and memorize so many cases lah. Okay, and then we go to the third part: loss of future earning. Loss of future earning is the confusing part. So what you need to put, loss of future earning, you have to put section 28A, subrule 2, subrule C, and subrule 1. Okay, so this one, you must take a look now. Okay, now itself, or at least after the class. Okay, so 28A, subrule 2, subrule C, subrule 1, okay, 2C1, I just make it simple for you lah. Okay, you cannot copy and paste from the statute directly. You must write based on the fact. I give you an outline. ABC had lost his job since he met with the accident. ABC was 28 years old at the material time. So I put dalam kurungan kurang daripada 60 tahun, and then subsequently I use the case of Tan Hairudin. Tan Hairudin will do, don't have to recite the whole case. If you can, will be better. But if you really cannot, just half of the case, enough. And ABC was receiving actual income from his previous employment as corporate executive. This one changed according to the question given. And ABC was actually earning a legitimate income, which is claimable. You use the case of Chua Kim Swan, because this case provide that. Why I purposely put legitimate income? Because illegal income cannot be taken into account. So, and I submitted that the provision of section 28A2C1 and 2 are satisfied. Okay, so do not engage in the argument of pre-2019 and post-2019 argument about the good health issue, about the 55 to 60 issue. No, it's not very important anymore unless the accident happens prior to this date, 1919. Okay, I introduced to you one mnemonic. The date of the current new amendment is 1919. Okay, at least you absorb nothing. You just memorize this thing. Okay, 1919. 1919. Also, you don't copy from this, but you write like this. Oh, how old is he? And then you just change less than 60, you put less than 55. And then the good health element, for example, you add in as simple as that. Okay, again, you use the case of Yang Saobia, Lim Po Chu. If you can find a case that is universally applicable, I am very much love that you use it like that. So you don't confuse yourself with you don't load your mind with so much of case law, and it is not so possible to, how to say, how to memorize all that case law, all together some more. And then, okay, remember what I say, 60-year-old thing and also actually income. So you cover in your first sentence. And then subsequently, your argument on loss of future earning, don't get confused so much. Okay, you use statutory multiplier as provided in this also. Okay, it will be preferred for you to buy this book. This book is from LPQB. I will not recommend you to use the BSc book because I have a few statutes. I'm quite kiasu in my exam. So I bought this. Why? Because I want to get real feeling, which page is it? So next time I flip straight away, it jumps to this when it is personal injuries. Okay. Another tricks would be you will be given with statute books before they give you the examination paper. So why not? You don't just put the book aside, you do this. Like my book, you can see there's a clear mark of like this. You clip the book, you mark, oh, this is section 7. Surely you know personal injuries is a compulsory question, and then the relevant law would be 7, 8, 12, 28A. Why not? You do yourself a job easier. You just go and chari section 7A and then you go and lipat it. Easier, isn't it? So you save some time on, Okay. So like this, okay, we continue. Okay, where were we? The statutory multiplier. Okay, it's provided in section 28A, 2D, and 1, Roman 1. Okay, and if it is less than, the plaintiff is less than 30-year-old, then you get 16 years purchase. Okay, this is so-called the purchase years law. Okay, and then if the plaintiff is over 30-year-old, the formula is 60 minus the age divided by 2, and then you get the S years of purchase. This one, you please write in accordance to the real age given to you. Okay, so the multiplier in this case is A. You approach like that, you write like that. Don't go and write so many things. Later on, susah. You don't have enough time to proceed with the third question. Okay, so with reference to case law, Marapan, Jacob Fong, the calculation of multiplicand is as follows. Multiplicand equal to income minus income tax plus EPF minus living expenses times 12 months. As simple as that. Okay, so whenever you are being provided with income, you have to use in the RM, how much belakang kurungan income. and also the living expenses. The thing is, the good part about this is not a mathematical test, You don't have to give exact, berapa ni darab? 15 ni berapa then you go and calculate like that. Waste time. You just give your amount as RMB at the end. You will not be penalized as long as you got the facts correct. Okay. Please don't waste so much time do calculation like a mathematical test is wrong. Okay. So loss of future earning. So in estimation of total loss of earning, the formula, mathematical formula, the following, by right, this is a mistake in typing. The mathematical formula is used. Just do like that. A times B, and then you get C. Don't calculate anymore. Don't waste your time onto calculation. Trust me, you need to rush. Okay. Loss of earning capacity. This is the tricky part. Okay. Usually loss of earning capacity. What's the meaning of future loss and also this earning capacity? It may seem a little bit same, but loss of future earning means the plaintiff, the victim, had really lost their job. And then this is the first condition. Second condition would be he didn't lose the job, but then the income that he had received for his employment had been tremendously reduced in comparison to previously, before the accident. So this will fit into the category of loss of future income, okay, or future earning, okay, LOFE lah. So this loss of earning capacity is usually the plaintiff will still have job, but probably on unpaid leave. There's no disturbance in his salary, salary ongoing, but he's just fearful. With this sort of leg, how long can I walk? I mean, for the next 10 years, by right, I should work until 60. So after 10 years, we know, and the doctor said, there is so-called substantial or real risk that I cannot walk further and I cannot be a lorry driver. So this is the situation whereby you use this loss of earning capacity. There must be a substantial real risk, and okay, and then the court will assess and quantify the present value of such risk, okay, in regards to the financial damages that could suffer from your plaintiff, okay? So it's a matter of keywords only. So you'll be sharp and catch the medical report, and also whether there's any fear by the plaintiff that he might lose the job. Okay, but the two criteria here you must not forget. So like usual, I don't think I wanted to remember this molecule case. For me, I remember the intra-Devi against IMR case and Tan Kim Chuan. This one, Tan Kim Chuan, also you can use it in illegal earning. And intra-Devi case, you can use it in contributory negligence as well. So this sort of case is called universal case. So easier for you, seriously easier for you. All right. So next we move to loss of, future cost of care. Future cost of care here, you must consider multiplier and multiplicand. So first we talk about multiplicand. Okay, don't get confused with the section 28A, the two, what we call the two, just now, this one, 2D1, 2D2. Okay, this one is allocate for loss of future earning only. The less than 16 years old, less than 30 years old is 16, and then subsequently you have to use the formula to calculate if it is more than 30. This does not actually apply on cost of care. Cost of care, that means you need a nurse to take care of you. You need a caregiver. And this caregiver should be a lifelong one. It's not a temporary one. Okay. So again, you can use the case of Yang Saobia. For me, I will write in a manner like this. ABC will be dependent on lifelong nursing care, okay, as indicated in the facts. In practice, ABC would be required to produce evidence to show that future care is required against Yang Saobia. You remember those cases, Yang Saobia, Limpochu, universal case, please remember. Thereby, he will be entitled to claim future costs of care. Then you show your understanding of law here. There is no statutory multiplier available for cost of care. However, it is at the discretion of two A, B, C, D. There are four methods. The court is not determined. It will depends. Because cost of care thing is something not so easily to be quantified, if you agree with me. Like you lost of salary, you say you're actually earning. I just need to assess your salary slip and then I calculate accordingly what is the amount to award. But cost of care, if you hire some non-professional nurse, the auntie lah, nanny, whatever, to take care of you, the price or the wages that you give to the auntie is lesser, probably you give 1,500. But whereby some rich person, if they engage with a whole team of medical consisting of doctor, professional nurse, 24 hours rotate, how you want to give this sort of cost of care? You get what I mean? The defendant will be definitely out of pocket one. Okay, so the court also realized this, so they did not have any statutory multiplier, and okay, but somehow in case of Marapan, they use multiplier as adopted in section 28A 2D 1 and 2. That means 60 years old, and then they use fixed multipliers of 16 and also the 16 minus 30 over 2, that formulation. And in Bujang bin Mat, okay, this is a good case also if you want to remember. Okay, the life expectancy of the plaintiff is taken into account, and then minus contingency. Contingency thing is at the discretion of court. For example, your life, okay, for example, you made the accident at the age of 28. So the average life expectancy of a male individual in Malaysia will be around 76. Okay, so 76 minus the age, you get a life expectancy. And then the court usually will deduct 1/3 up to him, 1/3 of 10 to show his fairness. Okay, and then times the market rate or the wages of the caregiver. Okay, something like that. In some case, the court even take into account of multiplier plus inflation rate. And in case of Wong Li Fat also quite universal case. The court apply none of above and use some annuity table. That means like insurance policy, 5 years, 2019, 2020, 2021, 2022, what are the payment? So they calculate according like that. So you can submit all this, but in a very quick manner, and then you must finally concluded that which method you use to claim as multiplier. All these four are applicable, and you will not be wrong. I will suggest you to go for statutory multiplier because you already calculate in your loss of future earning, correct? So you just copy and paste that one. What's the figure? Easy, okay? So the second thing, multiplicand, it will be determined based on current wages of the nurse that you have engaged with or market rate. It will be depends on the court decision. But for the ease of your discussion, usually the nursing care costs will be put up in the fact, so you have to use. So I will submit in such a way, adopting the case of Donnelly against Joyce, the appropriate multiplicand in this case would be based on the wage of the wife who have been not working in order to take care of the paralyzed plaintiff. Therefore, you can see this figure from the question given. So I just, because I want to move on, you see, so many things we cannot finish writing. So we really have to stop. And then what we call is you write down this and then you conclude as M, okay, as future cause of care. And then subsequently, you have loss of consortium. It is a type of deprivation of the benefits of a family relationship. Usually, is claimed by the husband for losing her wife. Her wife becomes, you know, paralyzed, wheelchair bound. Eventually, the whole happiness of the family is gone. Okay, so this is loss of consortium lah. Okay, if the fact said so, only you write. If no, don't write. Okay, the interest part, okay, I counter check with several people. They give me this answer. So by right, I thought it's 5%, universally across 5%. But you also can counter check at your level best. So I got these two. Okay, number one is interest award between the date of accident until the date of payment of the judgment. This one we will have to follow section 11 CLA, which is 8% in per annum. This one refer to your special damages. That means whatever medical fees, whatever nurse, the nurse wages before the trial, you already pay, isn't it? By right, you already pay so long, it should be entitled to higher amount of interest because you are out of pocket first. Okay, so this makes sense. 8%. And then you have another tier of interest that is the interest award between the date of award or judgment. That means to say, the date of judgment, the what we call the judgment is hammered by today, but then the plaintiff will drag their time, not necessarily today the judgment, tomorrow the plaintiff gives to you. Maybe they are asking for, hey, can give me a frame of time, 3 months, 3 months or 6 months. If let's say the claim goes to 1 million. So these are another tiers, okay, that 5% based on our practice direction of Chief Justice there. Okay, so you can at least you write interest okay. So my discussion is very simple. I don't mix things around. Okay, I will rely back on some other issues, miscellaneous issues, okay, which is deduction. I will write section pursuant to section 28A sub-rule 1. There shall be no deduction in ABC's claim on A. It will be depends on whatever he had received on let's say from insurance or gratuitous from charity fund, from his boss, whatsoever. Okay, so you must write something like that. Make it simple. Insurance payout amounted 15,000. You use the case of Watt and Mas or Su Chen Lin against Sunway Medical Center. And if there is any gratuity given by employers, you can use the universal case KR taxi against Sahara and any other written law. For example, SOCSO, okay, or insurance law or EPF law, whatever lah. Okay, the facts will tell you it is non-deductible. So you highlight this, okay? And then subsequently, probably you'll encounter some issues, if any, stated by the question. Then only you go for that. But you please remember this is of your argument. Okay. Prospective increment of salary, you rely on section 28A to C sub-rule 2. Okay. So the scenario provides that ABC salary has a good prospect of annual increment, 2,000 per annum. Okay, however, such prospect of increment cannot be considered by the court pursuant to this section. So you use the case of Chang Min Fen. Okay, you must be sharp. Sometimes the question try to trick you. So you must make a clear distinction between actual and prospective. Prospective means the employee, the boss only promise okay, based on various factors, based on, of course, whether the business make money or not, whether you are performing based on your merits or not, this kind of thing. Okay, and if the actual one, actual increment, usually it happens before the what we call the accident. You already got a new confirmation letter, but it was not enforced. This is actual lah. Oh, one very interesting unjust enrichment. Okay, unjust enrichment is so-called a fundamental in tort law. By right, the plaintiff should not get more than what he ought to deserve. That means the plaintiff suffer from certain type of damage. Since the insurance are paying out, why we need to cover? But the current situation of the so-called the laws cannot play a function in relation to restitution of the position of the wrongdoer and also the victim. It's not just this sort of corrective principles, restitution. Okay. Now the court held that tort law, as any other law, serve public benefit as well as to give deterrence in effect. So the unreached enrichment case, like the one you have one case, Dr. S. Underwood, S. Underwood case, as well as your Satish Bosnaran case, that one is already overruled. It's no longer the current law. The current law follow what the war against the Malaysia airline case, the one war against MAS, and also the Sunway medical case. Unjust enrichment is allowable because, like I said, the deterrence effect. The court wanted to what we call the deter people from wrongdoing. Okay, mitigating factor I'll discuss in later on. Okay, so contributory negligence, against you have discussed section 12, you must put by specifically you must put section 12 subrule 1. Okay, subrule 1. And lastly, duty to mitigate. Okay, duty to mitigate, again, I like this case, Intra Devi against IMR. As long as you get one case law support your the principle of law, you will not be penalized. Okay, so our right, ABC is under the legal obligation to mitigate his loss. But on the facts, the ABC already suffered from severe personal injuries resulting in his bedridden condition. It is submitted that ABC could not be able to mitigate his loss. Okay, this is applicable to those type of serious injury. But let's say if he can work, you must propose. You must propose. Okay, that ABC will need to find another job to mitigate his loss. The same case you can use over again, the intra-devi against IMR. Okay, so okay, as a rules of thumb, even though I think most of us will dislike it, you must memorize whatever I have copied down, especially the headings, and then subsequently don't you memorize like that, the heading first, and then subsequently you expand with supportive case law, Okay, so this is very important. So our new chapter will go to this one very simple, property damage. If you could identify the motto is damage, or the helmet is lost during the accident, lost is a Rolex watch, for example. Okay, you can plead under property damage. But this is a very small section. Okay, you can use the case law. I remember one, Parvati, finish. Okay, so next we'll go to dependency claim. Okay, so you are clear, personal injuries, you have no excuse not to memorize. This is the one that will definitely come out. Over the years, you fit through your past year examination, you must be familiarized with personal injuries. So the chapters, I mean, the section that is relevant to personal injuries will be section 28A and section 12, your contributory negligence. Please be systematic and be clear, okay? Then only you can know how to answer the question nicely, okay? So we go to dependency claim. Dependency claim, a lot of people got confused also with estate claim, okay? Last time, when I used to study, I also confused, frankly. I also confused. I asked myself one question: why on earth the parliament wanted to enact provisions that almost similar? To me, it's almost similar, Wakil C. Mati. You all agree, isn't it? Dependency estate claim only brought by the person. I mean, on behalf of the deceased. Okay, so now I started to appreciate. Okay, now I hope that I can make things very simple for you. Okay, in most of the time, section 7 and section 8 will be different. Section 7 will give rise to automatic right, to the person to initiate action against the defendant. Okay, I repeat myself. Section 7 will give assumption like rights, like local standard, local standard, because those who fall under the meaning of statutory dependent could initiate the action. Okay, you get what I mean? So you have to, before you jump into dependency claim with various heading, you must see the relationship of the disease, I mean the one that passed away, and the one that given in the scenario. Are they the child? Are they the wife or the spouse or grandmother whatsoever? Okay, of the deceased person. This one is number one to establish, because you need to know who are statutory dependent. Okay, the case law had told us that girlfriend, sibling, divorced spouse, niece, nephew are not considered as statutory dependent. Okay, now you have to start opening your Civil Law Act, and then start looking at your section 7 sub rule 2. Okay, clearly it states child, parent, illegitimate child, adopted child that can prove to be legitimate offspring of the so-called the disease, as well as this is the new amendment, person under disabilities. Okay, that means something wrong with the brain, or under the definition of PUD lah. That means okay, under the care of the diseased person, can be grouped as statutory dependent. So he can sue, he can sue immediately, Okay. So when the action of dependency claim can be commenced, that's why the time of death of the disease is very important, because section 7 sub rule 5 clearly stated that you have only 3 years, okay, 3 years to commence the actions against the defendant, okay, after the death of the victim. Okay, be very clear. Please memorize before you put anything about the dependency claim. Please put section 7 subrule 5 and section 7 subrule 2 in together, read together with section 7(11) of CLA. Okay, this is the definition. Okay, so the case refer again Chang Ching Ming, universal case. So I give you an example on how I will write on these particular issues, because dependency claim, if you have so many this sort of, if you are unlucky, you get personal injuries claim, you have to write so many already, and then dependency claim also so many already. Don't vomit out the law, as I said. So you write something like that. Being the wife of ABC, the deceased, Doreen would have statutory right to pursue the dependency claim pursuant to Section 7 Rule 2 CLA. So, and then subsequently, you want to bring out this Section 7 Rule 5, isn't it? You continue with the matter of the sentence. It is advisable for Doreen to commence the actions against BF. This is the name that you should put within 3 years from the date of the deceased pass away, i.e. on, this is the date of your exam lah. So I hope you remember, pursuant to Section 7 Subrule 5 CLA. Again, I use the case of Chang Ching Ming. Finish the whole thing. So headings of dependency claim, please memorize all. Okay, the confusing part would be the first one, the loss of support, and also by way of earning, and also by the way of service render. Okay, I do not expect you to really, how to say, be familiarized with all this after this lecture, because one thing is because I'm rushing time to teach you everything, because this class comes a little bit late, I have to admit. Actually, we plan to do earlier, but I'm stuck with my own LLM, as well as frankly speaking, I'm not so confident yet to teach, so I'm sorry on my part, but I hope to catch up as fast as I could. Okay, and this loss of support by way of heading, like I said, in loss of future earning, I already put in bracket. These are the things that confirm need to be written in your answer. Okay, namely actual loss, and then subsequently you have to use this section 7.3 and Roman 4 for your CLA, and then subsequently you have to use multiplicand and multiplier method that you have learned in the loss of future earning part lah. Okay, but they are not the same. They are not the same. Please don't confuse yourself. Different headings. Okay, so to satisfy the claim of loss of support by way of earning, so I will not reject the law, but in fact I will straight away apply it. I will say the Doreen, which is the so-called the executrix or administratrix of the disease, must firstly prove that there is actual loss of support. So on the fact ABC have been, and if not for his death, shall continuously giving Doreen monthly pocket money amounted RM 3,000. This one also you adapt accordingly to the question. And it could be established that there is actual loss of support. Yap Army case or Lim Chai On case. Use Yap Army shorter and easier. Okay. Secondly, what I use referring to sections 7.3 Roman 4. Okay, ABC died at the age of 37, less than 60, and ABC had been receiving earnings by his own labor or gainful activity as a this one you modify accordingly, driver in the factory. Again, you use the universal case of Chang Ching Ming, and you will not be wrong. Then you finish already, you conclude this person actual loss, and then this person less than 60 and earning. Okay, so you conclude these two already. Then you work on with multiplicand. The appropriate multiplicand will be derived, again, confusing, because the court sometimes take into perspective, that different perspective lah. Because common law, this one is not entirely called our tort law is not codifying, you know. So the common law can be a little bit creative, you know. So the court actually established two type of calculation. One is contribution method, which means how much the disease give to Doreen per month. As simple as that. That will be taken. Okay. Second method, the court went back to go and calculate income tax minus tax, the income minus income tax plus EPF minus living expenses pula. This could be reflected a little bit. The living expenses part lah, pursuant to section 734C of your CLA. But to make your time more flexible, don't calculate these two. You use one, easiest one. You can see Doreen get 3,000 pocket money, and then subsequently you see the income, don't bother. Just choose the one, contribution method, as your final submission. You just submitted that, oh, relying on the contribution, but at least I told you I know already, but it's up to me to choose contribution method, isn't so? You could not be penalized, okay? The multiplicand is 36,000, for example, okay, per annum. And then multiplier part, okay? Multiplier part, you can rely on statutory multiplier. If there is a statute, use statute, okay? Section 7.3 subrule 4D, you can have a look, same only lah. Less than 30, 16. If more than 30, you use the formula 60 minus 36 divided by 2, then you get 12. And then the loss of support is coming out from your multiplicand plus multiply with your multipliers. And then following this calculation, the proposed amount is RMX. Okay, no need to give exact figure, finish at this point. Then you move on. Okay, because a lot to discuss one, you know, this sort of question. So headings of dependency claim. Hey, I'm running out of time. Are you all tired actually? No, a few more slides to go lah. Then we finish this, then we can go to contract in our next class. Statement of claim first, then contract lah. So we hope to cover more chapters, subjects for you guys, you know. So hopefully you are able to bear with me for a few minutes more, okay? So loss of support by way of service. Okay, this scenario is in the case that the disease is actually not working, but he's giving services like all the housework, the housework he cover, the gardening job he cover. He is so much so a good husband. He send the children to the school, you know, buying food outside, or etc. Okay, so this is by way of service. Okay, so I will submit in such a way that further the court shall determine the multiplicand by considering the loss of the service rendered by the deceased to the statutory dependent when he was alive. Okay, by considering the loss of the services rendered by the deceased to the statutory dependents when he was alive, to which a monetary value can be placed. Okay, and some more, there is no statutory multiplier. So you use the case of Han Ping Sing here. The court used, this is previous, 55 minus 40 and made 1/3 reduction, resulting in multiplier of 10. So for this section, for this heading, there is no statutory provision of multipliers and multiplicand. So that means the court shall decide. You don't have to argue so much. And then the formula to calculate total loss of support by way of service will be, again, multiplicand plus multiply with multiplier. Then you get the RMY. Okay, so this RMY, RMX thing shall be important in your subsequent statement claim. Okay, So heading, another one, loss of consortium. Basically, according to Section 7, Rule 3, Roman 3 again, husband cannot claim for loss of consortium. But how about the wife? You can argue with the case of Ham Peng Sing, okay? Because the statute provide that husband cannot claim, but it is silent whether the wife can claim, okay, otherwise, okay? And special damages, special damages is whatever expenses incur on this is ABC had incurred several expenses on Doreen prior and after his death. For example, the medical expenses, how long he stayed in the hospital before he died. Usually there will be a bill. And funeral. Funeral, then you must use this section. Section 7.3 sub rule 2, okay, which is claimable. Okay. Bereavement, bereavement, you must discuss section 7.3b. Who can claim, okay, the child can claim, the wife can claim, as well as the spouse can claim, okay. So you must put your position, and the amount of claim is 30,000 now, in accordance to section 7 sub rule 3a, okay. These are the main point, 3b and 3a you must put in bereavement, okay. And then the deduction, again, section 7.3 sub Roman 1, there shall be no deduction where Doreen had received payment from, again, insurance, any gratuity, whatever disease saving, and you must discuss based on the facts given. But please remember this section, and you can use universal case of KR taxi again, okay. So, okay, last one. You must be feeling very tired now. Okay, like I say, estate claim, you must refer to section 8 of CLA. This is compulsory. Okay, you cannot simply write estate claim. So, in order for you to be having locus standi to sue the claimant, okay, you must go to court, and then you must extract the probate or letter of administration from the court to say that you are the administratrix or executrix of the deceased before you can initiate the action for the benefits of the estate. So I hope this is very clear. So different with section 7, as long as you are the statutory dependent, that means to say you are the parent, child, whatever, PUD, under the care of the deceased, then you can claim. Section 8 is not the case. For example, I have my family, I have wife and children, but the estate, I don't want to give to them. I give to my niece. So the niece can actually initiate the action by this way, court order. Okay, as long as you remember court order for grant of probate or LA, then you are more or less correct lah. Okay, there will be some overlapping claims with the dependency claim, and you should only choose one to avoid duplicity of the claim, because duplicity of the claim is not allowed under civil law. Okay, so the headings of estate claim is pretty simple. Okay, you get this is lucky for you lah. So basically, there are 3 headings. Okay, special damages inclusive of funeral. Again, you use this section 2 Lucy. Okay, in case of Maria, but it must not be overlapped with your previous section 7 lah. Okay, dependency claim, and the cost to extract the probate, medical bill, pre-death loss of earning under section 8 rule 2. Okay, general damages for pain and suffering, loss of amenities. Usually this occur when the victim did not die on the spot, admitted, for example, 2 weeks in the hospital or even 3 hours in the hospital, and he suffered grave pain and distress before he finally passed away. So this is how you claim, okay. And bereavement also is an overlapping claim with Section 7 dependency claim discussed earlier. So do not claim in duplicity, please. Okay, so I will write my outline as such, very simple. I'll write providing Doreen had obtained, because usually the fact will not tell you whether he got grant of probate or LA. So my proposed framework for you would be providing Doreen had obtained grant of probate or LA from court, she could act as executrix or administratrix for the estate of ABC. This is to claim on DEF. The claims are largely divided into the one that I have told you. You write like this, okay, based on the facts given. And then general damages. Okay, general damages for pain and suffering, you can say there was a lapse of 3 days, 5 hours between the death and also the accident. ABC disease was suffering from both physical and mental distress following the severe injuries that he has sustained. Therefore, pain and suffering is claimable. Case Maria. Okay, as simple as that. And please also consider in the event when you plead for dependency claim as well as estate claim, you must put in, if it is necessary, interest, contributory negligence as separate heading. Okay, this one I think we have discussed very well in our previous chapter. Okay, so like I said to you, if you are unlucky, dependency plus estate claim could come together. I think this one we need to discuss further in our statement of claim. I think this one is the hardest one. What to write, what to write inside the statement of claim. But please allow me a few days to prepare for it, and I'll get a nice template for you. So later on, you can distribute among your friends also. There's no copyright, don't worry. You can distribute this slide, modify accordingly, no problem. Okay. So far, are we still together, and are we still good? I have finished the class. Are we still good?
Yes.
Can understand? Who blind leading the blind? I hope not. You all can understand what I'm telling. Subsequently, you have to revise on these slides as well. Should you detect any mistake, or should you feel there's difference in argument, okay, because we are adversarial legal system, your constructive feedback and your critical feedback is very much welcome, and I'm sincere. Okay, please put in a group, and then we can settle accordingly. Okay. Yes, I will send the group. I will send the group with this slide as well as this recording. Because this is actually how I study. I travel. Last time I got a few clinics. I travel around, so I put this sort of video of Mr. Padiban, and then I play this video when I was actually driving. So this is a method that probably you can consider, because sometimes reading, your eyes get blurred, So you listen to somebody from the video, audio, whatsoever. This will help you to memorize. Okay. Oh, any question? Please put in the groups, and I shall be very happy. And I'm sure my colleagues like Mr. Gan as well as my master, Miss Christie, will be very much helpful to answer your doubts. Okay, hopefully we could be one of your helping hand in passing the exam. Okay, I shall see you soon. I shall see you soon. Thank you very much. Thank you very much, and have a nice day. Good day. Good day. Bye bye.
Yes, sir.
Thank you so much. Don't call me sir lah, just call me Chi. No problem. Thank you. See you.
Thank you.
Thank you. See you.
Thank you.
Thank you. Then I will leave. See you all.